That brings us to our main topic for today. And I thought synthetic data was an interesting definition because it thinks about the proliferation of all sorts of new information and new content in our systems. And today we want to talk about what happens when any of us can produce new content for any different purpose at the click of a button, or even maybe not at the click of the button, maybe just using our own voices, and how that manifests in spaces like regulatory agencies that use a lot of public commentary to decide how to shape policy. And so we're going to talk about two different pieces today. The first is an HBR article from Sean West and Stephen Heitkamp called Gen AI Makes Legal Action Cheap and Companies Need to Prepare. And then we'll compare it with a recent blog post by an appellate litigator you brought to our attention, Bridget, Adam Unikowski, who talks about this in the context of the National Environmental Policy Act. So let's start with the HBR article, and maybe you could summarize it for us, Bridget.
Yeah, absolutely. And we talked about this article when it came out, which was maybe a couple of months ago at this point. I feel like, and I can't tell you how many people, probably you too, sent it to me at that time. It's an interesting, um, I think, window onto this issue of will reducing the barrier to entry to legal process be good or bad, right? This is like one flavor of it, and we'll reserve for future conversations what it means in other contexts, like personal injury law and other ways in which reducing the barrier to entry could be a really good thing or maybe a really bad thing. But interesting conversations I think around. But this one's fascinating, and I'm going to take a step back before I describe what the HBR piece focused on, the specific case, to do like ad law 101, which is really dangerous because never even took ad law. But
Really?
um, no, never took ad law. Went through law school, never took ad law.
That
Yep.
was my favorite class in law school, was ad law.
Really?
Yes, I
Oh,
loved administrative law. I don't know why, but just really spoke.
well, I mean, honestly, I feel like it should be a required class because it's such an important source of law in our society. And if you don't understand sort of how administrative agencies, both the federal and the state level, function and what an important source of law their work is, I think it's hard to understand the operating system of our society generally. They're just it's I mean, some people call it on both, either if you love it or you hate it, like the fourth branch of government, right? The administrative state. But agencies are where a lot of really specific regulatory work is done by experts, right? Experts in whatever the agency's mission is. But one of the ways in which one of the requirements for new regulations from any agency is that they have to, if they have a new rule, they have to publish it in the Federal Register, and they have to publish the text, and also their justification for the rule, so the public can see, what the specific proposed rule is, why the agency thinks it's important, and then there's this public comment period, which it's literally an open public comment period, usually 30 to 60 days, and the people can, people can write in. Often it's obviously experts. I don't know how many uh, regular people are like checking the Federal Register every day for new rules that they want to comment on. But if you're in an industry that is affected by the rule, you submit a comment either in support or opposition or making suggestions for comments, for changes and consequences downstream that the agency might not have thought of. Potential legal concerns. There are entire, legal practices around this process, right? There are lawyers who do this and only this. And then the agency is supposed to review all those comments, synthesize them. If there's a substantial factual or legal concern, the agency has to address it in its final rulemaking process. And then that process can be the subject of litigation and often is the subject of litigation after the fact. Okay, that was a little bit boring. So let me get back to this HBR story and example. So Treasury, the U.S. Treasury Department, was proposing a cryptocurrency disclosure rule. I don't now remember exactly what the specifics were of the disclosure that it proposed requiring, but there was resistance from the crypto industry and a group that called itself Lex Punk Army, which was a sort of legal and tech group, used an AI bot and enabled really quick and widespread public commentary about this rulemaking. And they generated 120,000 comments, which is significantly more than you normally see in a proposed regulation like this. And it meant that the rule was able to be, delayed significantly because the agency had to work through all 120,000 comments and be able to like respond and synthesize them and then take them into account in its final rulemaking process. And so, it was this first like practical example of what we've heard, or I've heard, and I think you have as well, like lots of lawyers from the very beginning worry about as one of the doomsday scenarios about this technology and its potential legal use cases. If you can all of a sudden file 120,000 comments and frankly, it worked, delay the rulemaking and change the outcome just because you now have a technology that can make that happen and you wouldn't have been able to happen before the technology. That's the question I feel like I've heard from the beginning. Like, is that good or is that bad? Right? Do we want that outcome? Whether we want it or not, this is a perfect example that it's here. This now is possible, and so the HBR piece really was focused on what you probably should be doing and thinking about. What are your strategies if you are a business that has to, think about this regulatory these kinds of challenges. I actually think the authors are thinking beyond regulatory, but it's the what does it look like to prepare yourself for this new set of risks that hasn't been on our radar as for businesses or law firms until now, and that was, I think, a pretty interesting part of the piece. I'll pause for a minute to make sure. Do you think was there anything else that I should have covered before we discuss some of the recommendations?
No, I think that was great. And just to put a fine point on the one comment you made about the crypto industry, I think in the article, the authors say, this could just be evidence of an industry that happens to be really facile with technology, using its skills to inundate the system, or it could be a harbinger of what's to come in other regulatory landscapes. And the authors say they think it is the latter rather than the former. But because it's sort of an early case of people who do use technology well, that gives us like a little bit of time to think about what happens when this occurs across all different regulatory landscapes that we might not anticipate.
Yeah. The authors are really thoughtful in sort of placing this particular specific risk in kind of the larger geopolitical and economic disruption that's part of the world businesses are operating in today, and they write about that a lot. The more general um, geopolitical risks, and they make some suggestions, or like at least they say you should take it seriously, right? Like don't write it off as okay, the crypto people figured out how to do it. So, but that's, that's not going to happen in my business because we're not, whatever. But their point was you have to take this seriously as you think about how to prepare for this kind of risk, um, because it's absolutely possible in any industry. So I don't know. Do you have a thought on what if you're advising a business or a law firm and now you're advising them to put this on their risk register, right? We now have to like have on our risk register the possibility that we could have all of a sudden, 120,000 lawsuits filed against us tomorrow. What are the strategies for businesses or law firms? I mean, law firms are businesses, but what are the strategies that you would advise them to think about in preparing for this kind of risk?
Well, what the authors did something that I know you and I have taught in classes that we teach together, and I love that they did this, which is being inspired by other industries with analogous situations. So they draw from the cybersecurity landscape and they compare it to, I think, distributed demand, a DDoS attack, and
Yeah.
the way that cyber security experts deal with that, as I understand it, learning from the article, is pooling and aggregating information across companies so that companies can share in a centralized database. And they list a few in the article that are well known, so that if you're operating at company ABC across the world and I'm at a different company, I can benefit from your experience and be more prepared. And collectively, we can come up with a counter offensive, I guess, to something like this. And they talk in the article about how uncomfortable something like that would make lawyers because we keep everything very, very confidential. Handle privileged and sensitive information. But I think the point that they are making, that you and I have talked about in different contexts, is that we're entering a totally new era of risk in the way that we think about it as lawyers. And our discomfort comes from trying to apply the frameworks that we used in the prior era to this new era. But we're actually doing ourselves a disservice if we don't try to reshape the way that we think about sharing information, for example, to protect our clients from risk. So I think in the long term, their counsel would be for the whole profession to sort of rethink the way that we consider information. Would you agree with that and share
Yeah.
information with one another?
Yeah, or at least, think about the ways in which you can share your info. You can anonymize and share your information, which also has gotten a little bit easier with, this technology that can take unstructured data and, clean it in any way you want. And so yeah, it feels like, another collective action problem to me, though. Like, I think that their suggestion that we learn from cyber is a really good one. But we've talked about this in other contexts. I think, for lots of cultural and understandable reasons, there are significant silos within the legal profession. And I don't know who takes the lead on this kind of response management project, right? Like, who's going to say, hey, we all are running these legal businesses that now have this new significant risk, and the best way to guard against it is for us to think about a strategy that breaks down our silos. That I don't know who does that. I feel a little bit worried about, like, where we find the leader for that change management process within the profession. I don't know if maybe you found them in your in all of your consulting. I don't know.
No, I totally agree. I mean, it reminds me of the conversation around outside council guidelines and coming up with uniform, anonymized sets that you can use to sort of accelerate Gen AI adoption with your outside counsel, right? Coming up with structures that create different incentives for collective action. I don't know of anybody who's thinking that far ahead, though the article does talk about, I think they reference DLA Piper as a firm that is currently working with its clients to do red teaming, which is a term that we talked about before on the podcast, to sort of simulate what kinds of mass produced claims or regulatory filings might be submitted in the realms that affect their clients. And to me, that feels like an innovation that would be comfortable for law firms and also potentially provide a new service offering to clients that are trying to manage all of this risk.
Yeah. Yeah, it's like, I mean, I don't know. You'll know better than I do. I don't know how often law firms are doing tabletop exercises around, enterprise risk management. Businesses do it all the time, right? I mean, we actually do. We do tabletop exercises a lot. And it turns out it can be quite helpful, right, when you do have an emergency. But I don't know how many law firms are doing that besides DLA. It was interesting that DLA is doing it, but
Yeah, I have not heard of many doing it, although maybe they're out there and I'm just not aware of them. But it is a great way to sort of scenario plan and future cast, what could happen under different sets of circumstances. It also seems like because of the things that the authors point out, all of the geopolitical chaos and changing regulatory structures and frameworks, all of the law firms that are listening to this are serving corporate clients that are dealing with this complexity. And
Yeah.
just like generative AI strategy generally need help and need support in thinking this through. They don't have the time to now try to figure out what this Lex Punk army means for, their risk
Yeah.
assessment. So it strikes
Yeah.
me as a very forward-looking approach that DLA Piper has, and I think there are lots of opportunities like that now emerging for firms.
Yeah, it's interesting. It's like, yeah, again, I would actually think about how to use the technology to think about this new segment of ERM that you're going to have to think about, right? I would great startup idea. Those of you who are out there looking for a startup idea, something that businesses and law firms are going to need. I think it's pretty interesting.
Yeah, and in the meantime, I would say, a couple of thoughts around what corporate departments can do or what law firms can do until there's some sort of massive shift in the way that we think about it is education first and foremost. I think most people are probably not even thinking about this as an outcome of generative AI. They're thinking a lot about Gen AI, but not in this respect. I think also, as we sort of just suggested, workshops and tabletop exercises with your clients to walk through what the risks could look like and how you might respond together. And then I think having, some sort of protocol for what happens when there's an incident like this so that you're not then you might need to wait until something happens to actually have something live to respond to, but you want to have a plan in place in advance of what that response might look like. And all of that would require collaborating with people who have different types of expertise, cybersecurity expertise, data science backgrounds, ethicists, that kind of thing. And then I would just say, to your point about collective action, find industry opportunities where people are coming together to share how they're responding to this risk, would be the steps that I would take, and have a communications plan ready to go for if this were to happen in your realm.
Yeah, it's yet another example of where lawyers are going to have to get comfortable with the fact that we need to collaborate with people with other expertise. Like we're not going to solve this one on our own. We need partners outside of our expertise to really manage it, I think, well. So
I think that's right. Thank you for tuning in to 2030 Vision, AI and the Future of Law. If you enjoyed this episode, please subscribe to our podcast and leave a review. Stay informed and inspired as we continue to explore the AI-driven future of the legal profession. We'll see you next time.